Hi, welcome to your second Key Concepts lecture. In the last module, we took a broad stroke approach to learning about the corrections system. We learned about the goals and theories of punishment in the United States, the different levels of government, and the different players staffing the correctional branches. Today, we are going to get more in depth with the details of the different corrections options. You'll notice this module has a link to more news articles and a few videos to watch. I think that the textbook is missing a human interest component, and so we're supplementing with these articles. You may have also seen the two different sections of assigned reading this week, along with those extra articles and the videos to go through, and thought, Professor Corey, this is too much work. I validate you. It is a lot of work. And I think you can handle the work. The textbook that we are using is pretty straightforward. And since we're building on the concepts that we learned in the last module, the reading is also a bit easier. I will also remind you that this is a college level summer course. These courses are fast and intense. But if you feel like it's too much, then just hang with me through this module and the next module, because modules 4 and 5 are just one section each. And then, of course, module 6 is just the final exam. Our reading in this module starts off with a refresher of the different goals of punishment. The first is retribution, which I like to think of as the pure punishment theory, but is often called the just desserts theory. Under this theory, the goal is for the punishment to be proportional to the crime committed. It's the eye for an eye mentality, or the retribution theory. It has been a long-standing goal of There's been a long-standing goal of punishment in the United States. It satisfies the collective sense of justice. But there are, of course, ethical considerations, especially when thinking of the more serious crimes. As of 2025, the United States is split in half on the death penalty. Only 27 states allow the death penalty. Florida, a death penalty state, requires a unanimous jury to agree on the death penalty. So when you have a death penalty case, the jury has to be unanimous as to whether the defendant committed the crime. If yes, then there's a second trial where the jury then has to be unanimous that the death penalty is warranted. And here we have a graph with the number of executions since 1976. This graph was updated in 2023, and the number of execution is 1,625. And as you can see, the numbers kind of peaked around 98, 99, it looks like, and then they went down, and seemed to kind of stable off in the last couple years. The second theory is deterrence. The thought is that we will stop people from committing crime in the future with the threat of punishment. There is a general deterrence component that aims to dissuade the broader public from committing crimes, and a specific deterrence component that aims to dissuade an offender from reoffending in the future. In order to work, a potential offender has to be aware of the potential consequences and has to have the ability and time to think through the possible consequences before committing the crime. And as we know from our last lecture, this doesn't always deter or reduce recidivism if the offender doesn't have the tools needed to live lawfully in the first place, such as therapy for anger management issues. And then here below, I have the two theories. I listed out the 27 death penalty states. We have Alabama, Arizona, Arkansas, California, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, Nevada, North Carolina, Ohio, Oklahoma, Oregon, Pennsylvania, South Carolina, South Dakota, Tennessee, Texas, Utah, and Wyoming. You won't be responsible for being able to name all 27 death penalty states. This isn't really a memorization type of course. However, I think it's just helpful to look at when you're to know where the death penalty still exists and where it doesn't. So we see these two goals of punishment and deterrence play out in the sentencing options of incapacitation and rehabilitation. Incapacitation includes incarceration and civil commitment for individuals deemed mentally ill and dangerous. The idea is that by removing the offender from society, we can better protect the public's safety by stopping the offender from committing crimes. Though this is not a foolproof plan, as it's still possible to commit crimes while incarcerated and, in rare cases, escape confinement, And as we discussed in the last module, there are a plethora of issues as we deal with overcrowding, unsanitary and inhumane living conditions, and limited financial resources. Rehabilitation, on the other hand, says, hey, let's give the offender the support this person needs so this person can lead a lawful life. This can look like better education, cognitive behavioral therapy, job skills training, and substance abuse treatment. But again, limited funding and other issues make this idea very complicated to achieve in reality. The last few years has seen a rise in restorative justice, where we want to find repair and healing for the victims and communities impacted by offenders' actions. Last module, we watched a TED Talk from an expert on restorative justice in Colorado. She described a situation where a victim's family met with the offender while he was incarcerated and they were able to communicate with each other for over 6 hours. She described it as healing for the victim's family and for the offender. In a lot of states, it is not very common for such a situation to occur. What can be common, however, are victim impact statements. These are often read during the sentencing phase. In other words, the defendant has already been found guilty of the charged crime, and now the judge has to decide the defendant's sentencing. At this point, victims may be given a chance to confront the offender and express feelings. In this module, and as part of our prep work for the course, we were assigned a video showing Ali Reisman confronting Larry Nassara after his trial. Her statement is a lot like victim impact statements in that they are quite emotional. There's a lot of anger and sadness. Similar to a lot of victim impact statements, Ali Reisman spends the first half describing her experience and the lingering trauma from the offender's actions. Unlike a lot of victim statements, however, though, Ali then calls out the U.S. Gymnastics Organization for their past and present failings. It's uncommon because the U.S. Gymnastics Organization was not a defendant in that trial, so she's still seeking, describing the harm and lack of repair that she's had from the U.S. Gymnastics Organization, but they weren't a part of the conversation there. And I wonder how this would play out in the restorative justice effort should that have been attempted in the Larry Nassar trial. The criminal justice system would not have been able to mandate that a representative from the U.S. Gymnastics Organization be present for a mediation. I wonder if a statement or admission from the defendant on how he was supported by the U.S. Gymnastics team, though, may have helped Ali and the other victims attempt to reach a point of healing and repair. The offender was de facto sentenced to a life in prison. He did issue a public apology after hearing victim impact statements for 7 straight days. But the federal judge called him out. She read a letter that he had just sent her a few days before his apology, whereby he had still refused to take accountability or admit any guilty wrongdoing. Certainly, the denial of wrongdoing does not contribute to the victim's closure and repair. In addition to impact statements, there is a growing movement to increase the rights for victims throughout the criminal justice system. In the process of a trial, a victim often has to be consulted before the criminal case is resolved, either with a plea, being dismissed, or with a trial. And the victim generally has to have the right to be updated on how the case is progressing. A common misconception is that the prosecutor is the victim's attorney. This is not right. The prosecutor represents the people of that jurisdiction and is employed by the government. The victim can hire, though, their own attorney to help ensure the victim's voice is heard throughout the process. And as the reading notes, a lot of these goals can compete with each other. For example, a victim of a robbery might think an offender deserves life in prison, but a more reasonable resolution might just be a year in jail to be followed by rehabilitation programs while on probation after. Assuming an offender is sentenced to some form of incarceration, the possibilities include prison, jail, detention centers, and halfway houses. Prisons generally house offenders serving sentences longer than a year. There are 3 different levels: minimum, medium, and maximum levels of security. It's the Goldilocks levels. Minimum security prisons are often called camps or open facilities. There is greater emphasis on work release programs to help inmates better prepare for reintegrating into society and leading a lawful life upon release. Medium security prisons house inmates who pose a moderate security risk. There are stricter security measures here, and we still have educational and vocational programs available to help with reintegration. And the last of the Goldilocks group, maximum security prisons, are home to those who pose a serious threat to public safety, which can be defined in part by a history of violent behavior. Security and obedience is prioritized over freedom in these facilities. Life in prison is much like how it is portrayed in the movies. It is regimented, and inmates sleep in either a cell or a group called a dormitory. While prisons house individuals who have been convicted of a crime, jails, on the other hand, house both offenders who have committed a crime but are sentenced to less than 364 days and by individuals still awaiting trial. The rapid turnover of people housed at a jail can actually result in issues with resource management, effectiveness of rehabilitation programs, and meeting the physical and mental needs of the inmates. That said, there are also mental health and geriatric units built in the jails to cater to individuals needing the specialized support. Because of the wide array of challenges faced by the prisons and jails, there is an effort to decrease the number of offenders housed in prisons and jails. These options include diversionary programs, halfway houses, and release with electronic monitoring, or a GPS monitor. There are a number of diversionary programs gaining momentum for their effectiveness, as we discussed in the last module. There are specialty courts, such as courts for drug offenders, mental health courts, veterans courts, domestic violence courts, and restorative justice programs. Diversionary programs work best for, and are therefore usually limited to, first-time offenders or someone with a very minimal criminal background who wants to make the effort and benefit from the services provided in these courts. These measures don't achieve the goal of reducing repeat offenders if the offenders are not willing to do the hard work that they entail in the first place. Halfway houses, likewise, want to help offenders build the skills that they need to lead a lawful life. We also recognize the challenges associated with being incarcerated and then just being released back into society. As such, a halfway house can offer housing assistance, employment counseling, and life skills training and make the transition a bit more feasible and realistic. We also have GPS monitoring as an alternative to incarceration, where a GPS monitoring bracelet is attached to an individual's ankle. It has to be on all the time, and it has to be plugged in to recharge at points. So you end up just sitting next to a wall while the monitor charges. One can wear the GPS monitoring bracelet. We see the use of a GPS monitoring bracelet for individuals both awaiting trial and as part of sentencing. One can wear the bracelet and follow whatever bond conditions that the court gives before a trial. And if given as part of a sentence after a trial, it can be ordered as a condition of probation. The technology, however, isn't perfect, though it is pretty accurate. An offender can, of course, cut the bracelet off if they really want to, but once found, the offender would be reincarcerated. Well, let's talk about incarceration. If an offender is incarcerated, then we need to make sure the offender's basic needs are being met. As we mentioned in the last module, this principle is legally rooted in the Eighth Amendment of the U.S. Constitution. The Eighth Amendment reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." Basic needs include access to food, clean water, sanitation, ventilation, lighting, and a humane temperature. So if you're in the middle of a summer during a heat wave, you'd be entitled to tools such as fans to make the heat bearable. Not comfortable, but bearable. Correctional authorities are responsible for ensuring that these basic needs are met. This is way easier said than done, of course, especially when it comes to providing basic needs for the mentally ill. One of the assignments as part of the prep work in this module asks you to read a New Yorker article dealing with the horrific experiences of the mentally ill in Florida prisons, spurred by the death of a schizophrenic or an offender who had schizophrenia, who was forced to take a scalding hot shower for 2 hours, the journalist uncovered an entire system of failure and abuse when it came to the mentally ill. The article reported that when the state run mental health hospitals were shut down, and generally these were awful places to be, so not necessarily a bad decision to shut down these state run hospitals, but the patients who committed crimes were then transferred to the prisons. The correctional officers are charged first and foremost with keeping the prison safe. But as the article indicates, things can get out of hand, and an atmosphere is then created where it becomes very much unsafe to report instances of bad behavior. You will get a chance to go more in depth with these competing tensions of safety and health in one of the assignments for this module. Aside from the mentally ill, it is still often difficult to provide basic needs for inmates. Delays of treatment are common, and if there is treatment, it's common, to use a metaphor, to use a band aid on a gushing wound. Physical violence is also prevalent in these incarceration settings, both violence from the inmates and from the corrections officers. Officers need far more training to learn how to de escalate a situation without violence, and the prisons and jails need to be appropriately staffed. Understaffing greatly exacerbates these issues. Your reading from the ProPublica article really highlights that when this prison isn't well staffed, they not only may not get to a physical incident in time, they may not even know that something has happened at all until notified by another inmate. In that article, we learned of a situation in Mississippi where one guard from a tower was responsible for supervising 180 cells. A gang related physical attack occurred, and the guard didn't even know something had happened until another inmate alerted her a few hours later. By then, the victim was dead, and nothing could be done to help the victim. And then going back to how the prisons are not well equipped to handle the mentally ill, the special issues facing mentally ill population. Um, we read about the case of Darren Rainey. He was serving a short sentence on a drug charge when he died after being locked into a shower for nearly 2 hours. And this photo is taken from the Florida Department of Corrections, and it is a picture of Darren Rainey. And again, as the article, I think, well states, we're not saying at all that the corrections officers are bad people, but that they are not trained in how to handle the special issues that come up, and they don't know how to de-escalate situations. Darren Rainey was having some type of episode, which happens as issues get worse and untreated while incarcerated, and he ended up smearing feces all over himself. The guards took him to the shower to clean off, but the guards have left scalding hot water on for that 2 hours, and by the end of the shower, Darren Rainey was no longer alive. And it's tough because the guards struggle to even provide the basic needs for inmates, especially those facing um, special challenges, such as those with schizophrenia or other chronic health conditions if you're in one of the geriatric units. But we also need those guards to keep the other inmates safe. And here's some photos on this slide from the incident in Mississippi that we talked about, or that the infamous prison that actually got shut down in Mississippi. And just a really look at how disgusting and unsanitary and inhumane these living conditions were. And that the violence comes from both angles, both inmates and officers. So once we hope that officers can provide the basic needs of the inmates, such as living in an environment without violence, um, we also want these officers or the prison facilities in general to provide inmates with opportunities to better equip themselves so that they may actually lead lawful lives when they leave incarceration. Without equipping an inmate with tools such as job training, then the inmate just spends a fixed period of time incarcerated and is in a worse position when leaving incarceration, especially by the time you factor in the increased barriers to housing and finding a new job with a criminal conviction on your record. So it makes sense that the offender would just return to a life of crime. But if prisons are having a hard time finding the funding to adequately staff and meet basic needs, they are certainly not excelling at providing these types of opportunities to better equip the incarcerated either. And sometimes when released, you also have additional conditions as part of your release that make it even harder because you're already facing these really insurmountable barriers to find housing, jobs, and reconnect with family and build a social network. But then you have all these other restrictions from the court. And again, it's that competing need to keep the public safe and help the offender lead a lawful life. And we'll come back to this slide in a bit. We want to talk a little bit more about the other reintegration challenges. And one of the other integration challenges that I just mentioned is the offender has to rebuild a social network. Um, because while incarcerated, it's often that inmates are shut out from communicating with their family. If there's not a safety issue that keeps the inmate from communicating with family, then there may be a financial barrier impeding the communication. As the reading from the Marshall Project demonstrates, it is very costly to afford the communication that has been outsourced to private companies to provide. Additional funds are needed to cover snacks, calls, emails, and texts. And it makes sense in a way that there would be additional costs with communication because we don't want the offenders committing new crimes through the communication or acting in unsafe ways, so we need to pay someone to review the context or the communication. We also, of course, don't want items being smuggled into the facilities. But alas, a lot of the offenders are coming from families with limited means, and it's unjust to require these families to put so much money into maintaining contact with their incarcerated family members. And incarceration isn't the only way the correction system can achieve that public safety. We also strive to ensure public safety with probation and parole. So I'm going to go back to that other slide now that I said we'd come back to. And as we learned in the last module, probation and parole officers or the programs allow an offender to live and participate in society while supervised by a probation or parole officer. And often, there are very strict requirements imposed, such as curfew, travel restrictions, maybe in order to stay away from a victim if there was a victim in the crime, a requirement to look for and hold a job, to refrain from illegal substances, and otherwise live a lawful life. And those are just general requirements for regular old probation or parole. But we also have specially tailored probation programs depending on the underlying crime. For example, if the offender is accused of a sexually motivated crime, then the offender will likely have to complete a sex offender type of therapy, while also adhering to a number of statutory conditions, such as notifying adults of one's conviction when around children and staying away from schools and playgrounds. There's also a specific probation program for drug offenders and for those with mental health issues. Note that this is different from diversionary drug or mental health courts. If someone doesn't qualify for a special court, because again, these courts are not easy, and the most successful offenders are the ones that have a very limited criminal history. So, not everyone qualifies. And in the event that an offender does not qualify for a specialty court, then drug or mental health probation may be a more appropriate option. The probation officers have a heavy task of ensuring public safety by making sure the offenders are following the specific rules. When a violation of the rule occurs, the officer is required to file a violation with the court, and the offender has to go back to court to resolve the violation. Sometimes, if the violation is minor, then the offender can go back on probation. And sometimes, if it's not minor, a violation will lead to reincarceration. There are actually two types of violations. There's technical and substantive violations. Technical is when an offender violates the rules of probation, maybe misses curfew or a meeting with a probation officer or failed a drug test. Substantive is when the offender commits a new crime. When the violation goes to court, The offender is essentially facing the same sort of process when the offender was first arrested, no matter if it was technical or substantive. The judge is notified of the allegations of how probation or parole were violated, and if necessary, an attorney is then appointed for the offender, and at some point the violation is resolved, either through a plea, or it's dismissed, or there's what we call probation violation hearing, which is basically a mini trial without a jury. The judge hears the facts and then decides if there was a violation, and then also decides the new sentence. Sometimes these violations can be resolved that day if it was something minor and you're just going to put the offender back on probation. But if it was something more serious, like a new crime that was committed, these can take quite a while. And then again, the offender is in jail waiting for this probation violation hearing to take place. And it is hard for everyone when the offender commits a new crime while on probation because, one, the public safety may have been endangered depending on the crime, and two, we were not able to help the offender lead a lawful life right away after being released the first time. The probation officers, in addition to helping ensure the public safety, are also responsible for helping offenders reintegrate into society. This job is particularly difficult on a practical level if the offender wasn't given any reintegration or rehabilitation tools before probation, and because the probation and parole officers carry such enormous caseloads with access to such limited resources that may actually help the offenders. In general, the biggest challenges that offenders find themselves facing when reintegrating into society include finding stable housing, employment, social connections, managing personal finances, and overcoming the stigma associated with having a criminal history. And then, of course, there may be additional challenges if the offender had pre existing mental health or substance abuse issues that were left untreated while serving a sentence. It is likely that those issues, if left untreated, probably got worse while incarcerated. And reintegration must help those individuals in order to reduce the risk of recidivism. We've talked about the use of halfway houses, job and vocational training to help mitigate these issues. There is also an effort to use mentors or create reentry circles that provide support and insight to those reintegrating from someone who has already done it themselves. These circles can also help foster a social network for the reintegrating individual, which is also essential for success. At the core of all these reintegration efforts is a reminder that all offenders are human. As the ProPublic reading indicated, these are people. They are human. Take Desmond Mean. He's there pictured on the bottom of this slide, standing behind the podium giving a speech. Before this picture was taken, Desmond was unable to cope with substance abuse on his own and was in a bad cycle of being arrested for drug crimes. He ended up incarcerated. When he was released, he was at an all-time low, addicted to drugs, homeless, jobless, and no social network. He tried to commit suicide by standing in the middle of the railroad tracks waiting for a train to come. For some reason, the train never came, and he ended up checking himself into rehab. And again, at the end of rehab, he was going to be homeless until a friend from rehab took him in. He ended up completely turning his life around and has dedicated himself to helping convicted felons reintegrate. He went to law school, became a director of the Florida Rights Restoration Coalition. He was named by Time magazine as one of the 100 most influential people in the world. He helped pass an amendment in Florida to restore voting rights to convicted felons, and he was Floridian of the Year in 2019. As incredible as his story is, I think it's important to realize that Desmond had to blaze his own trail. He was clearly given very limited assistance, if any, upon his release to help with reintegration. Yet these programs are supposed to exist. As our reading mentions time and time again, there is a huge resource issue. Most of the people incarcerated are not bad people. They may have committed unlawful conduct, but they were punished and served their time. And then they were released back into society in a position that was worse off before they went in. But for the programs that we do have that are funded, however limited that may be, how do we tell if these rehabilitation and reintegration efforts are even working? We need to know so that we can create future policy decisions. Well, the answer is that we generally look at the recidivism rates. That is usually defined as rearrest, reconviction, or reincarceration following release. As the reading mentions, there are a host of issues that make measuring this challenging. Those details are beyond the scope of this course, but it is important to know that measuring whether a program is working is very difficult due to all of the factors involved with the rearrest, reconviction, or reincarceration, such as socioeconomic factors, prior criminal history, substance abuse or mental health issues, access to supportive net services, willingness to engage with such services, and extent of one's supportive network. In addition to recidivism rates, we also want to look at whether one has been able to maintain employment, housing, and whether one has been able to establish a social network. And that, my friends, is it for Module 2's Key Concept Lecture. As far as things to study and know this week, you want to be very familiar with the goals of corrections, how rehabilitation reintegration programs work and their limitations, the rights of victims, the dangerous and often inhumane conditions that we may see from the understaffing and lack of resources given to incarceration facilities, how probation and probation violation generally work, and an understanding of why it's important to provide offenders with help to reintegrate into society. Until next time.